Welcome to The Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program has been created to educate, inform, and help you with law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. As we say every week, we provide information and resources that'll help you decide whether you need or want to contact a lawyer. Perhaps will help you to determine whether or not you can handle some issues yourself. If you do need professional counsel, you'll be better prepared, and as a result, so will the professionals you select. Either way, you'll save time, money, and hopefully achieve better results, which is our goal for you. The Bazar and Associates law firm in East Providence continue to offer their expertise, their time, their energy, and their insights on the various issues we tackle. And we want to welcome and thank Dave Bazar.
Thank you.
So today we're going to tackle employment issues. Know your rights, and there are wrongs, plenty of them. Issues in the news today provide more than enough for us to discuss. Employment law is intended to help both or protect both parties, both the employer and the employee. And of course, our focus is going to be on covering the things that go awry, and many do. Of course, Wells Fargo is the main target, or the first target today. What do you need to know about those unfair practices as an employee, whether it's about your pay, it's about retaliation, discrimination in the workplace, harassment, firings, which is what was happening with Wells Fargo, what's inappropriate, what should be likely to be subject to litigation? Let's talk about it. Meanwhile, I think we probably should start just a little bit about a primer on employment law. I understand that it started back in industrial revolution days, early 20th century, when we were so upset, the workers were upset about the oppressive practices. So there's supposed to be some coverage against injury in the workplace. Let's make sure there's standard work week. What are the kinds of things?
So a lot of laws developed out of the Industrial Revolution, from workers' compensation, which was developed to give someone who was injured on the work site or workplace a quick remedy, because the only time, the only income that anyone would normally have is from their job, and a loss of income for any period of time and while you're waiting out a lawsuit is very devastating. So trading off the quick remedy of replacing those wages for giving up some rights, for example, pain and suffering and that type of thing, for an injury that took place on the work site, was how workers' compensation laws developed. Then, of course, there were safety issues, and I remember there is the famous Triangle Fire in New York City, where workers were killed in a textile factory because doorways and exitways were blocked off, and there was only one way in or one way out, and the unsafe nature of the area where the people were working with all the flammable materials and all of that. So that led the way to having safety regulations in the workplace, and the formation at some point of OSHA and all of the safety requirements that are part and parcel of any work site. And then, as you're talking about labor standards and hourly wages and work week, 40 hours a week as the maximum you would work without overtime, and all of those things that developed out of that. And of course, the rise of unions to help give the worker some equal footing in dealing with their employers.
Apparently, one of the issues early on was the child labor laws. You could have someone 7 and 8 years old working in manufacturing. Well, I guess that's less of an issue these days, but certainly it was an issue in the time. And currently, we have issues that are around employee health care and equal pay for equal work and other discrimination issues, which we're going to tackle now. But certainly there's been a mindset to watch, or have Congress watch, that there is protection for the workers, even without unions, although this did happen later.
Right. The unions were certainly very effective in helping change some of their practices and give employees more bargaining power in determining what's fair and equitable in some of that. But some of these other things that you're talking about, which are covered by discrimination and laws against that, and this standard work week and the standard rules as to whether a child can work or not work and what has to be in place, protecting children. As you said, at the time the Industrial Revolution came about, we were, prior to that, an agrarian society, farmers. And so it was not uncommon for young children to be out in the fields with their parents and other workers. And so when we became more industrialized and there was need for labor in factories, children did supply some of that labor, and so their risk of injury and death even. And so that was something that the lawmakers took into consideration in taking back and making sure that there's safety for everybody, including and especially children.
Good. So before we get into this very contentious Wells Fargo story, explain what at will is. Apparently, in nearly every state, there's presumed at will. You work or serve at the pleasure of your employer. What does that actually mean? What can you explain that a little bit more?
So Rhode Island, for example, is an at-will employment state. And so that's where a difference between someone who works for somebody without a union and someone who works under a union contract or an employment contract can be differentiated. So if you're an at-will employee, what that means is the company can let you go for any reason. They don't have to give you a reason. It's just that we don't need you anymore, or we don't like how you're doing your job, without giving you any specifics, as long as it's not based on some discriminatory practice. So if it's not because of some protected rule or reason, then the company can just let you go, no questions asked. Whereas if you work under a union contract, they have to follow the rules of the collective bargaining agreement before they can let you go. Or if you have your own employment contract, they have to follow the rules of that contract.
And I guess we might be having time to discuss some employment contracts include a non-compete clause, which are supposed to, those are supposed to protect both the employer and employee, and often those are subjected to litigation because one reneges or whatever.
Right, and what happens oftentimes is, again, there's not really this arm's length bargaining that takes place, so that the employer many times will impose on the employee certain conditions, including non-compete clauses that can be a little overreaching, and that's where a lot of the litigation can come in as to what's reasonable for a non-compete in terms of length of time, area, and what areas are covered on the non-compete clause.
So the kinds of things that you're touching on, David, are really supposed to mean that things are fair and just. So that's a good springboard for this notorious story about Wells Fargo, a great place to begin. So 5,300 Wells Fargo employees were fired over 2 million phony accounts. Whistleblowing later on prompted HR to retaliate by firing them. It's one thing if you don't like getting bank fees, David, it's yet another when you didn't even open the account and you're getting slapped with fees too. So the essence of this story was about the fact that the people who were working in for Wells Fargo suddenly have imposed quotas, and if they couldn't make them, they actually made them up. That's the long story short of it. So it makes sense that your various divisions in a company might have sales figures and quotas if you were a salesperson. This touches on, are quotas okay? Is that a reason to fire someone? Maybe, maybe not. Please discuss. And then what about the fact that people were doing things that were highly inappropriate, absolute fraudulent, and if they were whistleblowing, suddenly some very terrible things happened to them. How can that happen in this day and age?
All right, so yeah, I think you have to look at that situation and break it down into different components. So where did the policy come from? Who was responsible for the policy? That's one of the first things you want to look at. If you go to the bottom of the list here and say, all right, there were workers who were opening up bank accounts that were fraudulent, and they were doing it because of a policy set that was above their pay grade, so to speak, and they were doing it at the direction of people above them. Well, first of all, they're wrong to do it, but should they be fired for doing it? I would say unless the people above them are getting fired and the people above them and so on up the ladder to wherever these policies were created and directed, and if the CEO, for instance, was aware of this and instituted it, or it came under his watch, then it should start at the top, not the bottom. Now, if it started at the bottom and these were just people who were saying, I've got to meet my quota, but there would be no penalty for not meeting the quota, that's a different story. So you have to look at, determine, and break down exactly what happened in this situation.
So you set up what should be the right way to look at this. And as the story unfolds, of these 5,300, only a dozen cases did I read about that were in various interviews. But the ones who were fired, even Elizabeth Warren, I guess, was involved with this in Massachusetts. But one of the employees said, it was my boss, whose boss, whose boss. So in other words, it was absolutely a top-down issue. It wasn't just at the employee level thing. I think I want to keep my quota up. I don't know if they weren't really a commission set, but they just had a quota. But once they started doing this, they were finding that as more people found out about it, this really isn't legitimate. And there were so many different kinds of accounts, whether they were checking accounts, credit accounts, fraudulent emails. And so when the whistle was blown and it finally reached, I guess whistleblowing has to reach a certain level before anything actually happens. But once it did explode, explode, more employees came forward. So if they tried to complain, if they said to their boss that there was something that was wrong, nothing happened. So this could only go on for so long, and it finally does reach a place where it becomes a sufficient critical mass. So in the workplace, David, if someone is asked to do something that's fraudulent by their boss before they're even fired, what should they do?
All right, well, I want to tackle a couple of the things
there are
that
so many.
you talked about. I saw one story about a woman who was a whistleblower and complained, I think, to HR that in this Wells Fargo thing about what was going on, and she was fired as a result of that. She's got a very good case against Wells Fargo for what they did to her.
Yes.
I think in my memory of that story was that she was out of work for a good period of time before she got another job.
Yes.
And it was not with Wells Fargo, obviously, it was with somebody else. But she should be compensated not only for that time that she was out of work, but for what Wells Fargo did to her for, I would say, improperly firing her for whistleblowing. Because even if she's an at-will employee, that is not a grounds to fire somebody, and you can be held liable for doing that.
You were talking about, and it's true, there's this one person, but there are several one-person stories that we're going to discuss. So in terms of fair business practices, wrongful termination in and of itself, one person or each one individually is reason to have a lawsuit, right?
Well, absolutely. If you're treated unfairly and improperly by your employer, whether it's discrimination or being fired for whistleblowing, and there are statutes on that, or for any other protected thing that you do, you have a claim, and it can result in a lawsuit or a settlement, perhaps, but there's definitely a claim against the company for that wrongdoing.
So the first thing that's supposed to happen if you are the employee who sees that this is wrong and you're getting pressure, you're feeling harassed, I assume that the first move is to think about going to your HR department or to the boss, whoever that might be. That's the first line, right?
Yeah, yes, depending on the company and the structure of the company, usually that is the process. Your immediate supervisor, or if your immediate supervisor is the problem, the person above that, or if they're the problem, HR. There's usually, in bigger corporations and companies like Wells Fargo, a procedure, work guidelines that you have, and if you follow those and they then hold you liable for doing what they've told you to do, I think that's a claim.
And another employee at same Wells Fargo company said that there was an ethics hotline, which of course he thought he'd avail himself to. Guess what the consequences were? Retaliation and firing. Yet another. So if you've gone through what should be considered the proper channels, either A, you went to the HR person, no satisfaction, you're fired. You went to the ethics hotline, still you are fired. Does this absolutely underscore the validity of your case and the likelihood that you are going to prevail if you decide to go to a lawyer? I assume this is not something
Right.
you handle on your own.
Right. So we've talked about these in other types of cases. You want to make sure you have your documentation in place, both of what you're complaining about and what process you took and how you did it, so that it can be followed, whether you did the complaint by email and print a copy of the emails. And I know this time of year we don't like talking about emails and all what goes along with that. But yeah, I think documentation of everything that you did and what you're complaining about and how you can document all that's really important. And then if you're retaliated against, you then have the evidence, so to speak, to take to the attorney to follow up on.
Another one of these employees, if you just isolate the case, it's even more interesting, but one of these employees said he was fired for undue absences, 8 in a row inside of a week and a half. That in of itself might be, well, employee at will, we don't want someone who's tardy, you're out the door. However, in close proximity, he had just blown the whistle. So now that's never mind employee at will, and we don't like someone who's showing up late for work and sets a bad example and doesn't produce. Now you have someone who's being harassed, and obviously that correlation, does all he have to do just prove that he had blown the whistle, had filed something with HR, and then 8 days later, 10 days later, he's fired? Is that a very good case?
So there are defenses to these cases, and one of the defenses can be, that's not at all why we fired you. But then it really becomes a question of fact for a jury or a fact finder to believe whose story is correct. Were you fired because you were late? What does your employee manual handbook say about being late or being ill or time out of work and all of that? And why were you out of work? Were you out of work because you were being harassed for blowing the whistle? And was that something that flowed from that process and that act? So again, there are defenses. So if someone just blows the whistle and they're not really blowing the whistle on anything, but they're trying to do it to protect the fact that they know they've been written up 7 times and they're going to be fired on the 8th time, and the 8th time's around the corner and whatever. So the blowing of the whistle on nothing is not a defense to, we had a right to fire you. On the other hand, we're saying we're firing you because of what we have a right to do, but that's not the real reason. Someone, a fact finder, jury is allowed to sort that out and determine what the right answer is. Correct.
So you're one small employee and Wells Fargo is one large company. Does one small employee, before this escalated, one small employee, does he feel that he can absolutely sue such a company and prevail, or is he more likely to say, oh darn, and just forget about it because he can't fight City Hall, such as they would figure?
It's a proof kind of thing, and an evidentiary proof is really difficult maybe for one small guy, unless he's done what we said, is to document everything. And it's going to be hard for a law firm perhaps to dig in against Wells Fargo, who's just going to bury you in paper and everything when you try to prove what you're saying. So certainly when the avalanche of evidence comes out, it makes those cases much easier to pursue. But it is not at all unreasonable for one person to say, this is wrong, this is what I did about it, and to bring that claim against Wells Fargo.
David, what's the correct way for a whistleblowing employee to proceed? He sees something's wrong, maybe looks the other way or is not quite sure, but then it seems very apparent there's something clearly wrong. Yes, you always speak to the documentation, but what should happen past the fact that he has 10 items of proof that something was fraudulent? What should happen next?
Well, what the person who has concern about what's going on should do is first and foremost look at, if it's a big company, the employee handbook, the manual that tells you what process you should take to follow up on concerns. And usually there is something in there. If not, the next thing I would do is I'd go to an attorney, I'd lay out the issues, because depending on the industry and what you're doing, banking is regulated. If you work in the securities industry, finance, that's all regulated. There are ways of going about voicing your concern. So I would want to hire an attorney or go see an attorney before I did anything to make sure I followed whatever the industry's right practice is for voicing the concern. And I think some of what the issue is going to be is what is the basis of the concern? How big an issue is it? If it's blowing the whistle on some small violation of firm practice that doesn't really affect a lot of people, then there's a process that you might take through the company's own procedures. If it's something major, I definitely would want to talk to an attorney before I start taking that on.
See, this certainly had been going on long enough, and to a degree that it was so enormous that there were such fees against the account holders, or the not really account holders, the fraudulently created accounts. So apparently there's restitution for all of the victims who had the accounts fraudulently opened, and they're made whole. I'm not so sure that we know yet what the last story is about each of these employees. But so if someone's fired, there's going to be litigation. That may take some time. One of these employees said, my reputation is now sullied. Number one, he's named as a litigant. Number two, he's known as a whistleblower and a litigant. Number three, he has some issues about his security dealings now. That is absolutely holding up and ruining, I think the word was verbatim, ruining my life, unquote. What can he do? I mean, how does he have to pray that the case goes in his favor? Otherwise, he's losing his house, his wife, his life, his work. What happens, David?
Yeah, that's what I was saying earlier when I said it's not just a claim for that period of time where you couldn't work and have wages. It's a claim for all of the damages that you just laid out and that person would have suffered. And absolutely, in that case or in any other case where you have been wronged, in this case by Wells Fargo, but it doesn't matter who it is, that's what bringing these cases is all about. And you said we haven't seen the end of this yet, and I know we haven't, because I wouldn't be surprised if at some point some of these folks don't group together and file something, more on a class action type of level or a group litigation, because as you said, litigation's expensive, but there's so many of these people, if they group together, they could probably sue as a group.
But in the meantime, these individuals, I think, are suffering greatly, banking on, literally, figuratively, hoping that they're going to have some sort of restitution because they're out of jobs, and the likelihood of them getting something in a comparable, they're suffering. Obviously, they're suffering. And from what I understand, at $3 million that Wells Fargo has been hit already, that is a pittance. It's 1% of one quarter's revenue, which certainly isn't much. The greater deal is that the more this has hit the news in every stripe, that people who are patrons and members and are likely to pull their accounts, and down goes the stock share. That's probably where they get slapped.
Right.
That's their retaliation. So if it isn't a firing, David, in a workplace, just general harassment, you can't quite put your finger on it, but suddenly everyone is either snubbing you or maybe even trying to set you up. This has happened also in this Wells Fargo situation. Before they're fired, there's trouble just within the workplace environment. What do you do about that?
A hostile workplace environment, that type of situation, is really, in many ways, you can treat it the same as a wrongful firing, because it's really pretty much the same thing. It's a constructive firing in some ways. So again, I would contact an attorney who does these areas, and this is a specialized area. Employment law is a specialized area, so you want to make sure whatever attorney you talk to has a knowledge base in that area. Discrimination, hostile workplace, constructive termination, it all is subject to litigation and a claim that you can definitely bring against your employer for doing those things.
Okay, and one other question about this. If you are a line worker, you're a teller, there may be a handbook that outlines your duties and responsibilities, but somehow in that job description there was never a listing that said you have to open up X number of accounts per week, per month, per year. Is it okay and fair for a company to suddenly go back and say, and now your new chore will be to open up X number of accounts or whatever. Is that legal, lawful for them to suddenly change that? And if you can't or don't make those quotas, is that a reason to be at will fired when the employer changed the job description?
Well, if the quotas are a goal instead of being mandatory,
Okay,
which is
that's the point.
probably the right way to do that, because how can you mandate what you have no control over? Can I ask you as my employee to try to upsell somebody when you go to a movie and you say, I want a small soda, and the guy behind the counter says, would you like a medium for a quarter more? Well, you're not going to fire that person if I say no, because he has no control, or she has no control over whether I'll spend a quarter more for a soda. But they follow so if they follow your request, so to speak, to try to upsell me, and you do it, then you've done your job. I suppose the Showcase Cinema, for instance, could say to their employee, if you don't say, will you buy it for a quarter more, you refuse to do that, that could be a legitimate grounds to say, well, we're going to terminate you because you're not doing the job we asked you to do. You're an at-will employee. But they can't terminate you, or shouldn't be allowed to, for me saying no. So just like that, if the employee at Wells Fargo is said, we'd like you to try to open 500 accounts a year, and you open 200, but you've asked everybody, would you like this account, would you like that? And you do your job as trying to, so to speak, upsell the consumer, then they shouldn't be allowed to fire you for failing to meet their quota. So if they implement that quota while you're, I mean, even if it's a quota that they have coming in that's unreasonable, I don't think it's grounds to fire somebody.
Someone who's just in sales, quotas, I think, are pretty typical, and they often, management will reshuffle the cards and say, you did this, now you have to do this much more to even be on an equal par with what you were before. But if someone who is absolutely not in that line of business, namely sales, and they suddenly are mandating that they do it, I can see, as you're saying, cross-sell them, ask them, want fries with that, that's fine. If you're unwilling to ask, that makes sense. But mandating that you sell 17 more bags of fries is a very different story. That's a good point.
And, you know, if you're a salesman in a certain type of business, you might get commissions. Well, that's based on you're making legitimate sales to somebody and getting a commission. Now, if you start making fraudulent sales so you can get a commission, that's when I asked the question at the very beginning, where did this come from and who's responsible for what? Because if the rule was, we would like you to open up X number of accounts and we're going to pay you $10 for every account you open, but there's no problem in the sense there's no consequence if you don't open them from us as far as keeping your job, but you start creating accounts that aren't correct, then you should be fired for that, because you're now doing it to benefit yourself.
And as that story unfolded, initially the CEO was saying it's really the employee's fault, they weren't doing right. We would never want our employees to do that, but clearly with enough whistleblowers they could no longer support that story. It was clearly not.
And that's why I said you had to dig in on it. You know, that's what he says. Well, is that true? Because if that's true, then perhaps we're looking bottom up instead of top down, but it wasn't true.
Very important. So we hope that these issues have been enlightening to you on what you need to know and what you need to do and how to do it. Please stay tuned to The Law Matters, because of course the law matters to you.